It might make the case all the easier, but it would be quite radical to say that someone who is in custody, would it not? Someone who is in custody for violating a statute can, while in custody, bring a 1983 action to challenge the constitutionality of the statute under which the person is serving a sentence?
That's right, and that's why we're trying to hold the line and at least have the court reserve the question.
Well, they have to have the credible fear of prosecution, and if they're in custody for that crime, they're not going to be committing it again.
So certainly we think there
At
would
least
be,
not immediately.
So certainly we think there will often be Article 3 constraints. Of course, we understand an individual to be on custody when, say, they're on supervised release, probation, parole, and so there may be instances where someone—
Why would someone who is in custody have to show in order to have standing to show the likelihood of being prosecuted again under that statute? The person is already serving time, already is having his liberty anyway.
I think it would, I would like to just say for a minute why we think it makes sense to draw this in custody, out of custody distinction for these prospective challenges, because we do think it is about a concern about an end run around the habeas statute in two respects. The first is, I think this court has expressed a concern that if an individual in custody obtains a judgment from a federal court— may I finish? Thank you. From a federal court that necessarily implies the invalidity of his conviction and thus his confinement, he may be able to take that judgment and use it to spring his release. That would certainly be the case if the judgment came from this court. Then he would be able to seek habeas release regardless of where he was in the habeas process. At minimum, it would create an acute tension between a federal court judgment that demonstrates the unlawfulness of his confinement at the same time that he has a state judgment, his conviction, which would say he can be unlawfully held. I think this court section 1983 jurisprudence is designed to avoid that tension, but importantly, none of that tension exists when the individual is out of custody, as this court in Woolley recognized, because he's already released. He can't take that judgment and use it to do anything to affect his confinement.
Thank you, counsel. Justice Thomas. Justice Alito.
If you were writing the opinion, could you just give me in a couple of sentences what you think the rule should be? A summary of what you think the rule should be.
We think the court should limit its decision to prospective suits from individuals out of custody, identify this as a straightforward application of Woolley, and that should really be it. It can make clear that its decision does not address any retrospective suits, including suits for damages. That's the second question presented, where we're with the city. And it can also make clear that its decision does not speak to the relief available to individuals in custody where there's a greater potential for conflict with the federal habeas statute.
Okay, and that's pretty complicated, but thank you.
Justice Sotomayor. No. Justice Kagan. Justice Gorsuch.
Maybe one further adornment to your two-line, maybe five-line rule. How about parole?
If an individual is on parole, we do understand that person to be in custody, and therefore we would have we would reach a different result if they tried to bring that prospective challenge.
And that's because, again, habeas would be the appropriate relief in those circumstances too.
Exactly. We think when a person's in custody, the appropriate vehicle for testing the constitutionality of their statute of conviction is habeas.
Okay. And I just want to ask you a question about, as Justice Kagan points out, Heck has some very broad and pretty unqualified language. And you've got a footnote, oh my goodness, footnote 4 in your brief, in which you point out that the petitioner has disclaimed any interest in using this judgment to expunge his record. What if that weren't the case? What if the petitioner avowedly brought the suit as a step toward expunging his record? Would that offend habeas? Would that pose a problem?
I don't think so if the individual is out of custody, because at that point, as long as he's not asking the federal court, of course, to directly nullify the effect. So if he says, I want a declaratory judgment because I'm suffering collateral consequences from this conviction, and I want the court to invalidate the conviction so that I don't suffer those collateral effects, then we do think that that would be barred. But if he seeks purely prospective relief, we don't think the court needs to inquire into what his ultimate aim is with that judgment. At that point, the availability of any future relief will depend on the remedies that the state has chosen to offer. So if the state wants to take that federal judgment and consider it in an expungement proceeding or clemency proceeding, that's up to the state, but that doesn't present the same sort of tension with federalism and comity that a judgment when someone's still in custody
So
would.
maybe adding a sixth line to your two-line, that a declaratory judgment seeking a declaration might be a problem too, but a purely prospective injunction is different.
Well, a declaratory judgment is always hitched to the harm the person alleges. And so if the harm they allege is, I want to engage in religious expression moving forward and I can't, so I want a declaratory judgment, that's fine. But if the harm is, I'm suffering harms from my conviction, that's not, because that asks the federal court to sit in review of a state court judgment, which of course would offend deeply rooted principles.
I think I've got the two lines now. Thank you.
Justice Kavanaugh?